Hello, everyone. Welcome back to the show. Well, every week on Power of Attorney, we ask our viewers to send in questions about the show topics. And this week's issue is a big one for so many of you. So we have a lot of viewer questions, and we're going to go ahead and get straight to those viewer questions. This one says, how much notice does my landlord have to give me before stopping by and entering my apartment? My lease does not have any language about this.
Well, unfortunately, this is an area where the law is not clear. You know, it mostly talks about a reasonableness standard. So if you had a lease, read it. This viewer said they looked at the lease and it doesn't have it in there. But unfortunately, there's no bright line rule, 24 hours, 48 hours, 72 hours, that sort of thing. I would say that because the landlord has a duty to let the tenant remain in what's called peaceable possession of the unit, they can't just use dropping by or coming to inspect as a harassment type tactic. So, and a lot of times this issue comes up in the context of repairs. We were talking about that earlier. You ask for a repair. When you ask the landlord to make a repair, you need to make sure the apartment is available. So, you know, that actually happens quite often. Well, I reported it and the landlord's like, hey, I tried to come and, you know, I couldn't get in. You changed the locks in it. You weren't supposed to do that. Or, you know, I came there and you wouldn't let me in. So you're really looking at a reasonable standard, and you're also, if you do have a lease, a very common lease provision is that the landlord has a right of access to make repairs or to just inspect between like 8 to 5 or something like that, reasonable hours. So.
Okay, all right. Another question here says, is it true that if I don't immediately notify my landlord about something damaged in my apartment, the landlord can withhold that from my security deposit because the damage is my fault?
And that one, in that really, there's no immediately. You don't have to make that report at any point in time. But if the damage is actually your fault and exceeds and is beyond what normal wear and tear would be, and normal wear and tear is really, and we talked about earlier, but it's really up to, you know, when you get in front of a judge, the judge will determine what's normal wear and tear. But if it is something that you broke, you are responsible to fix it or repair it, or that will be taken out of your deposit if it's greater than the normal wear and tear.
Okay.
But there's no duty to report.
Yeah, and just to add to that, I've seen these leases where it has absolutely nothing to do with whether the tenant really is at fault. They've just got one of these ridiculous provisions in there that says if you don't report it immediately, then we get to just blame it on you, even if the ceiling just caved in all on its own, and that suddenly it's your fault because you didn't report it immediately. And just like common sense would dictate, I'd say the law is consistent with this. That's a bunch of baloney. It is not. If it's not your fault, it's not your fault. The lease can't suddenly make it your fault. And it would be, if it's a problem with the building or the structure, that is the landlord's responsibility. They can't make it your responsibility just because you didn't report it immediately.
Yeah, and there are, in Louisiana law, there are 2 warranties to tenants that even if the landlord puts it in the lease that it's waived, or that they write, you know, that it's the opposite of this, these 2 warranties cannot be waived. And one is the warranty of habitability, that the landlord has warranted that this place is habitable and fit for you to live in. And the second one, which Laura touched on, is the warranty of peaceable possession, which means that you're going to be able to live in the house and not be, you know, disturbed by the landlord coming in at 3 in the morning to check on the pipes, or any sort of harassment or anything like that. So those are the 2 warranties that all tenants have, regardless of what your lease says.
Excellent point.
Okay, all right. Another question here says, from the landlord's perspective, can I kick a tenant out if I find out that the tenants live like slobs and are destroying the property?
Yes.
That's a simple answer.
Well, but what you want to do as a landlord, just like with a tenant, check your lease, because frequently for that type of a lease violation, not maintaining the property on the tenant side, you're going to want to see if, as a landlord, you're required to give a cease and desist notice, or whether you're required to give the tenant a right to cure. And in one of our previous segments, we talked about the eviction process a little bit, and that the first 5-day notice can be waived. But if you have, as a landlord, a provision that adds these additional protections, that isn't waived. That's considered a separate additional notice protection. So check it out. If it's in there, do your due diligence, give the notice first, and then if the tenants don't correct it, you know.
Yeah, and just
Take
to
action.
add to that, if your tenants regularly keep dirty dishes in the sink and they let their dirty laundry pile up, that may not rise to the level.
I wouldn't think so.
But if the place is such a disaster area that it is getting overrun with rats and cockroaches, and everybody in the surrounding area is being overrun with these insects and vermin, and smells emanating from the place, and it's a disaster area, which is in fact doing damage to the structure and causing real problems and becoming a real nuisance. I think now you're getting into the area where it's doing the damage that any landlord, of course, should have every right to evict them.
Does it have to be that extreme, though? What if the landlord sees the direction in which, you know, this situation is headed and wants to go ahead and nip it in the bud? I mean, you know, this question, you know, if the tenants are living like slobs, that could be very subjective, right?
Extremely subjective.
So how do you, I mean, what's the advice there? I mean, does it have to be an extreme case, or is it just the landlord feels very strongly that, you know, the tenants are not taking care of the property the way he or she would like them to?
We see this come up more, I would say, I see it in subsidized housing cases actually more than in the private market, where you may have a landlord that, you know, wants to maintain certain housekeeping standards, and where you're going to really see it a lot is if the landlord lives on the other side. And that's a typical thing in New Orleans. You know, if it's your home too, you're going to feel more strongly about it.
Sure.
And, you know, if you're just talking about a few dirty dishes or some clothes laying around,
Or maybe not keeping the grass cut
most
as
judges
often.
are not going to evict for something like that.
Okay.
But and it's going to depend on how many times. If it's a constant problem, though, like you've warned them and you've established your record, the judge may very well say, "Hey, even though these were more minor items, you keep doing it, and so I'm going to have to evict you."
Okay, all right. Another question: there was a robbery in the apartment next door to mine, and several cars on my street have been broken into. I'm scared for my safety. Is this grounds to terminate my lease?
Short answer on that is no.
No.
It is not.
Okay.
You know, your lease is a contract, as John has stated, and that contract, nowhere in there provides for that. You know, we've never seen a lease that says if your neighbors, something happens to your neighbors. But you know, in New Orleans especially, we see a lot of areas that have a lot of crime problems. But you know, that's why we say before you move in and before you sign that lease contract to kind of check out the neighborhood. You know, ask around and look into that.
Yeah, the instances where a tenant can get out of a lease early, you know, when it's not a disaster or it's not some other kind of unusual situation, they're actually pretty limited. Louisiana doesn't have a bright line early lease termination statute or code article. Occasionally you will see in a lease that if I forfeit my deposit, or maybe I pay an extra month's rent, maybe I can get out of a bad situation, or maybe I've taken a job somewhere else.
Right.
I need to move out of town. But the only folks that there are a couple of federal laws that give protections for early lease termination in limited circumstances to certain folks, and one of them is military folks in the military. Let's say you get called up on active duty, you know, you can get out of your lease early and not have to worry about being sued for the rest of the months. If you're a domestic violence victim, and if you're living in subsidized housing, there are some protections there. When the safety of the family is in jeopardy, or the domestic violence victim is in jeopardy.
And to be clear about that, that's only for subsidized housing.
That's
that
correct.
does not include
so
private.
far
So
in
far,
our state.
right? Okay.
And then the last situation that occasionally comes up where a tenant can get out of a lease early is if they are disabled or become disabled while they're living in the apartment, and they need a first floor unit, or they need an accessible unit. You may be able to get out of your lease without penalty.
Well, I want to add to that because I take a slightly more aggressive position, and that is the following. If you have a written lease, and the lease has some of these outrageous provisions in it that we've mentioned, we've given examples of, and a lot of times they do, because these landlords, they're not lawyers, and maybe they don't know any better, maybe they think they're being clever, and they have these provisions that make you pay the cost if something breaks. They have stuff that says just things that are just unlawful. If that lease is, if it's one of those leases, in my opinion, depending on the case, you may be able to break the lease by saying, you had me sign a lease that is unlawful. Now, this is the kind of thing you would need to consult with a lawyer about. You don't want to just try and play your own lawyer here, but if you're trying to get out of a 12-month lease, a 6-month lease, early on in the lease, you may be able to get out of it because the lease is unlawful. And that might not be something that Southeast Louisiana Legal Services gets involved in, although you might look at a lease and give an opinion if you think it's a good lease or not for people who qualify for your services. But that may be an out for you. That's all I'm suggesting. Without, again, it depends on each individual
Everything's
case.
fact specific. Yes.
Wow, and I can't believe it, but we have already quickly come to the end of our second show. I know it has gone by so quickly. Amanda and Laura, thank you both so much for being here. And want to remind our viewers out there that if there's more information that you need, you can always visit your website. That's the Southeast Louisiana Legal Services. And also, we were talking a lot about the repair and deduct. Well, we have those guidelines that we are going to post on the website. So if you missed that or you just need to go over it again, please go to the website and you can get all of that information. Thank you, ladies, so much for being here.
Thanks.
And if you'd like to not only see those forms, but get more information about everything we talked about on these 2 episodes, visit us at johnredmannpoa.com. Also, be sure to follow us on Twitter, like us on Facebook as well. We'll see you next time on John Redmann, Power of Attorney.